Good evening, everyone. Thank you so much for joining us for our panel presentation on the Equal Rights Amendment, hosted by the Queens Bench Bar Association of the San Francisco Bay Area. My name is Kara Wild, and I'm the Secretary of the Board of Directors and co-chair of the Amicus Briefs Committee. The Queens Bench is the oldest women's bar association in the Bay Area, celebrating its centennial anniversary this year. Part of its mission is to promote equality and opportunity for all women through education, programs, and community outreach. That brings us to this evening's program. The Equal Rights Amendment simply states, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Right now, the ERA is closer than ever to being ratified as the 28th Amendment, and recent events have reminded us how much we need it to be part of our Constitution. This panel will delve into the history and relevance of the ERA. Throughout the discussion, if you have questions for the panelists, please submit them in chat, and we will collect as many as possible to provide the panelists during the program and the Q&A portion at the end. But before we begin, I want to make a couple of quick announcements. For those of you who are eligible to receive MCLE credit, we will be posting a SurveyMonkey link in the chat box at the end of the program. Please copy the link and fill out the information in order to receive your MCLE certificate. Also, all attendees should have received a copy of the materials for this evening's program in the email with the Zoom link that was sent earlier. Now I want to thank all those who helped make this event possible. Alicia Justin Cook, chair of the Queens Bench Domestic and Sexual Violence Committee and the board's newsletter editor, who worked on this event with me and who will be taking your questions during the program. Beverly Brand, first vice president and chair of the Queens Bench Programming Committee. Kimiko Akia, second vice president and co-chair of the Queens Bench Education Committee. Claudia Brisson of Marin County Women Lawyers for her input, and the Marin County Women Lawyers for being a co-sponsor. And of course, I want to thank our wonderful panelists and esteemed moderator. And with that, let me introduce our panelists. Linda Coberly is the managing partner of the Chicago office of Winston & Strawn and serves as chair of the National ERA Coalition's Legal Task Force, made up of leading constitutional scholars working toward ratification and recognition of the Equal Rights Amendment. Helene de Boissier Swanson is the co-founder of Katrina's Dream, created to carry on her late mother's dream of seeing the rights of women upheld by the law. Judge Barbara O'Hearn is an esteemed longtime member of the Queens Bench who served as a congressional intern during the peak of the Equal Rights Amendment ratifying process. And Senator Patricia Spearman, state senator from Nevada. In 2017, Senator Spearman sponsored State Senate Joint Resolution 2, which supported Nevada's ratification of the Equal Rights Amendment. Nevada later became the 36th state to ratify the amendment. We are fortunate to have her for a limited amount of time this evening. And finally, our moderator, Kimberly Ellis. She was appointed as the director of the San Francisco Department on the Status of Women by Mayor London Breed, is a longtime progressive activist who has fought for the rights and representation of historically underrepresented groups on the local, state, and national level. Thank you all so much for being here.
Thank you.
Good evening, everyone. I am Kimberly Ellis. I will be your moderator for today's conversation. I want to first start off by thanking the Queens Bench Bar Association for putting on this event, the event committee, and also a special shout out and thank you to Emberly Cross from Croc, who connected me with the organization. It is my honor to be here to host what I believe is an incredibly timely conversation, particularly coming off this past weekend, March for Our Reproductive Rights. So I'm honored and grateful to be here and be in community with you all. So with that, let's get started. I want to first start off by grounding the conversation in the history of the Equal Rights Amendment. And would love to start off with you, Senator Spearman. I know that we only have you for a short amount of time, so if you would just talk a little bit about the historical perspective as it relates to your personal experiences with the ERA, when it was first introduced, and where we are right now.
Thank you. And I too would like to thank Queen's Bench for sponsoring this, and I am honored to be a part of this esteemed panel. I will stay as long as I can just because I had another pressing engagement, but this is important. This is as important as that one. So first of all, I remember I was very young when I first heard about the ERA. Wasn't really sure what it was about, but long story short, I kept hearing about, well, women are burning bras, and this is something to do with equality, and I wasn't real sure. But anyway, grew up and thought that the ERA had died because it had not been ratified, and it was not until Jeanette Dean, who introduced me to Helene, and I understood that, wait a minute, it's still alive and there is still a way to get it done. It was no question for me whether or not I would carry the bill because equality is important to me. All kinds of equality are important to me, and this was another way to get the arc of history to bend more towards justice, if you will. The first time that I had the bill, I carried it in the Senate in 2015, but my party didn't own either of the houses, and so it never got out of committee. Brought it back in 17, and we were able to get it done in 17, and it is probably one of the great honors of my life that I was able to stand on the shoulders of so many other women and men who had already paved the way. And I use this example, my name may be on it when you start looking at, resurrecting it, but I'm standing on the shoulders of people with white knuckles, that were just hanging on, just knowing that one day we're going to get there, one day. And so they held on long enough for me to show up on the scene. And I'm just honored that I could be a part of the pendulum swinging in the right direction. And the ERA to me means so much because as a legislator, we're doing piecemeal with laws in terms of equality. I had another bill that was fortunate to get passed after 3 times, the pay equity bill here in Nevada. It is illegal now in Nevada to pay someone differently based upon their sex, and there's some stiff penalties. Also was a part of a bipartisan bill that meant that if there's ever DNA involved in identifying a suspect in a rape or sexual assault case, then there's no deadline, no time limit. So we're doing this piecemeal, but you know what the ERA would do? The ERA would mean that those laws could stay in place, but now there's a higher level, and Linda, I hope I get this word correct, higher level of scrutiny, because now it's not just you violated me, but now when the ERA, is in the Constitution formally, you have violated my constitutional rights. And so it is very important that we get this into the Constitution, extremely important.
Thank you, Madam Senator, for that. And talking about the bare white knuckles that you referenced and the strong, broad shoulders upon which we all stand, Linda, I was hoping you could take us back a couple steps even more and talk about sort of the legal background of the ERA's beginnings. You're on mute.
There we go. Sorry, it was bound to happen to somebody, so I'm glad I just crossed that barrier, and now we've had a speaker on mute already. Well, it's great to be with you all. The ERA was written in 1923 by Alice Paul and Crystal Eastman in the wake of the passage of the 19th Amendment. And they realized as soon as the 19th Amendment was actually in the Constitution and removed sex as a barrier to the vote, that it wasn't enough. We also needed an amendment that prohibited discrimination on the basis of sex. And they started working on that amendment right away. And unfortunately, it took many years. It took 50 years to get a sufficient number of votes to get it passed in Congress. As you all may know, we're speaking to a group of lawyers. The process for amending the Constitution is set forth in Article 5, and it requires a 2/3 vote of the Congress, and then ratification by three-quarters of the states. And it took until 1972 for the ERA to garner enough support across both sides of the aisle to pass in Congress by a 2/3 vote. And in fact, it had even more support than that at that time. It had very broad bipartisan support. It was a part of the political platforms of both of the political parties. And it was extremely popular. In fact, the first states that ratified it did so within hours of it passing in Congress, and there was a quick succession of ratifying states over the next couple of years. Then the ERA started to run into some more difficulty as the 70s moved on, and the anti-ERA movement began to really galvanize. If any of you haven't seen it, I highly recommend, mostly for its entertainment value, the TV series Mrs. America, which is fun to watch, if only for its music and its clothes, which are fantastic. The costumes are amazing. But it also, I mean, it tells a story and dramatizes some of the advocates who were pushing for the ERA at the time, and Phyllis Schlafly, who was famously an opponent. And there's some controversy over that series because some speakers, including Gloria Steinem and Ellie Smeal, have talked publicly how they think it actually elevated Phyllis Schlafly a bit too much, and made her the demon of the ERA story, as opposed to some of the other folks, many men who were standing behind her, and had an incentive for lots of reasons to oppose the ERA. But it's a great series to watch, and I definitely recommend it. It's a lot of fun. But as the controversy brewed in the 70s, we saw the impending time limit for ratification. So, taking a legal step back, Article 5 doesn't say anything about time limits. And for the first 150 years or so of our republic, there were no time limits on amendments. It wasn't until the early 20th century, with the Prohibition Amendment, that Congress began to put a time limit on ratification. Originally, it put those time limits in the text of the amendment itself, and that's what the practice was for the first half of the 20th century. In the 1960s, for a short period of time, Congress began to move the time limit, and it was usually a 7-year time limit, into the proposing clause that proposed the amendment for a vote by the Congress. And that's where the ERA's time limit is. It is in the proposing clause, not in the amendment itself. And legally speaking, that's an important choice, because what it did was reserve for Congress the power to change the amendment later on. And arguably, it gives rise to a legal argument that an amendment that has a time limit for ratification in the joint resolution itself, that time limit actually can't stand in the way of an amendment that has passed all the constitutional hurdles to become part of our Constitution. So in the late 1970s, the Congress, by a simple majority vote, chose to extend that time limit by another 3 years. Unfortunately, no additional states ratified during that period. So 1982 arrived, and we had only 35 ratifying states. And that's where things stood for another couple of decades. In the meantime, though, one important thing happened, and that impacts these legal issues, and that is that the 27th Amendment became part of our Constitution. The 27th Amendment is about congressional pay, and it is known as the Madison Amendment because it was proposed by James Madison at the time of the founding. And it took 204 years to get the appropriate number of states to ratify. And all three branches of the federal government have recognized that that amendment is duly ratified and part of our Constitution. So what the Madison Amendment did was really put to rest any idea that Article 5 contains some kind of contemporaneity requirement where all the ratifications have to happen at the same time. Obviously, that didn't happen for the 27th Amendment, and it is today part of our Constitution. And that kind of frames up the current status that I know other folks on the panel are going to talk about.
Wow, thank you so much for that brief but thorough history lesson of sort of bringing us to where we are today. Let's talk a little bit. I want to hear from Judge O'Hearn, who was a congressional intern during the 70s in the midst of the ratification process, as well as seeing up close and personal the oppositional forces that you were having to battle. So could you share with us a little bit, Judge, about your experiences during that time?
I am very happy to, but I have to qualify because I am a government employee, that my employer is the state of California and my agency is an Office of Administrative Hearings. So I'm not appearing here as a judge, and anything I say, anything I comment on is on me only. It's not on behalf of the state of California or the office where I work or any state agency. Always have to get that out of the way. So I go by judge in my workday, but I don't really I'm not really a judge here. So I want to just fill in a couple gaps tying into where we were, because Linda gave a lot of the history. I want to fill in a couple little tidbits of history leading up to that and up to my internship. And one, we're coming up on the Queen's Bench 100-year anniversary. But we're also coming up to almost a 100-year anniversary since this amendment was introduced. But it also took 72 years for the 19th Amendment to pass. So patience, I guess. But anyway, Linda mentioned who wrote who authored the amendment, but who introduced it were two Republicans, a senator and a representative. And the representative was the nephew of Susan B. Anthony. So it's kind of who you know in politics. As politicians, you probably know. So after that was introduced, there were two times after it had been introduced in 1923 and reintroduced every Congress that there were finally hearings. But as Congress can do, and this was in 1948 and 1956, the resolution passed, but they put in a rider, and the rider accomplished the very purpose it wanted, which was to kill the proposed amendment both times. So even though they got to hearing, they finally got to hearing, oh, but we're going to insert this in here, and that blocks it. And that's kind of another, the same kind of legislative stuff we see, right? But in 1970, as mentioned, they finally got some things going, but the part of that was preceded by 20 leaders of the National Organization for Women disrupting Senate subcommittee hearings, demanding that the ERA be heard by full Congress. And so that was that same year that Shirley Chisholm gave a very spirited and impassioned speech to the House of Representatives supporting the ERA. And just to kind of skip through, because we've already covered, when it was going to the States. And in 1978, that's when I was a law student intern in Congress. And this was exactly the time of these extension hearings. So one of the things I did in that work is I reviewed the testimony from hearings in 1977. And I got to witness and see some of the further hearings in 1978, in which that's where I got to see Phyllis Schlafly up close, sort of up close. And she called herself the chairman of the Stop ERA. That was her term. The other person who was somebody speaking at that time was, I think that was when Barbara Jordan spoke as well. Yeah, Barbara Jordan spoke in support of it, and Phyllis Schlafly against it, among other people, of course. But actually, in the November 1977 hearings, kind of leading up to all this in 78, the House committee had hearings. Several people testified, including Ruth Bader Ginsburg, who was then a professor at Columbia Law School, and among the experts discussing the congressional power under the Constitution and the Supreme Court cases interpreting the power, which Linda can explain way more than me. And I'm glad we have your expertise. But Ginsburg testified that Congress not only had the authority, but the responsibility to extend the time in light of, at that time, relevant political, social, and economic conditions, which repeat itself from time to time. So when I was a law student intern, I had it. It was, you could sense it was historical at that time. And after my internship ended, it was a semester. Then there was a march in Washington, D.C., and that's the photo behind me. I'm in there. You may not recognize me. But 100,000 people came to that march. It was just amazing. And the spirit of the march matched the polls of the country, where 66% of the people supported that amendment nationwide. So that's what got us, continuing to introduce resolutions until we finally got states, beginning in 1908 with efforts from Helene and Senator Spearman and the other states that followed after Nevada. So that's my contribution for the day.
Thank you so much for that. And, I hear sometimes from different folks talking about, women have equal rights. What's all what the fuss and the hubbub about? Let's talk a little bit about, the folks who may not understand the relevance and the importance of the ERA today, and why we still need to get us over the finish line and to get this done. And also why Title VII isn't enough. I'd like to start with you, Senator Spearman, again, just knowing that we only have you for a little bit longer, if you would share your thoughts.
So let me start with something that I said when I testified before Congress in 2019. I think I ended my testimony with these words: for those who were born in privilege, they have no idea what we're talking about. For those who were born in privilege have never had to worry about, am I being paid the same as my counterpart? Those born in privilege have never had to worry about if they were wrong, would they get justice? Those born in privilege have never had to worry about walking into a room and somebody asking them, are you supposed to be here? And so when we start talking about the relevance of the ERA, it puts to rest all of the, say this as diplomatically as I can, all of the arguments that ignore fact. And the fact is, we are already equal. We're not asking them to give us equal rights. What the ERA does is it says, I need you to respect the equality that I already have. Recognize that. And so without that in the Constitution, we will always be clawing our way uphill, always be clawing our way uphill. You look at what happened in the pandemic, and I hope I get these statistics right, but I think it's something like close to 80% of the people who were laid off and will never go back to work were women. When you stop and you think about the people that we used to call low wage earners, well, when the pandemic hit, we called them, what was it we called them? Oh, necessary workers, right? And most of them were women. When you stop and you think about these things, so we've always been at the place where we are holding up society, where we're doing the things that are necessary to make sure that life is better for everyone else. And so when we talk about the ERA being a part of the Constitution, what we're actually saying to them is recognize after almost 300 years, I am already equal. And as a Black woman, that's really important to me because, you know, I've got to fight to make sure that people understand that just because I'm Black, it doesn't mean that I'm second class. I'm also a member of the LGBTQIA community. That doesn't make me second class. And so when you start talking about equality, I'm talking about equality across the board. It is important that we get it done. And isn't it curious that when you started talking about pay for Congress, who at that time were mostly men, it was okay to do something for men after almost 200 years, but it is not okay to do something for women or people who are other than men. And so this is important. And this is one of the things that I hope that we will remember. The fight is long, but we're almost at the finish line. We can't give up. We can't give up. No matter what the challenges, no matter what the roadblocks are. And I often say to people, you know, when it comes to the fight for equality, there ain't no quitting me and there ain't enough bad in you to make me stand down. And so we're going to win this. We're going to win this. We'll just keep fighting. That's what we're going to do.
I want to call you Coach, Coach Senator Spirit. Got me fired up and ready to go. Linda, what are your thoughts on this?
Well, so the ERA fits. So first of all, there are a lot of people who say that the ERA is only symbolic at this point, and I disagree with that for lots of reasons. But I want to start with that, and I'll use a quote from Justice Ruth Bader Ginsburg, who said, "Even if it were just symbolic, isn't it a really important symbol?" So to me, that's a reason to do it, not to not do it. You know, every constitution written in the world since World War II has an equal rights guarantee on the basis of sex, every one of them. And the United States played a role in creating most of those constitutions. And it's really a national embarrassment that we don't have an equality guarantee in our Constitution. To get practical about it, I think there are a couple of places where the ERA could make a huge difference. I mean, obviously, that if you look at the text of the ERA, it protects against discrimination under the laws, discrimination by the government, by the United States or by any state. And so it would apply in some places where, for example, Title VII, which applies to kind of private employment conduct, doesn't apply. So in the context of law enforcement, in public employee pay equity, in military service and opportunities. Law enforcement is one of the most important ones. If you think about untested rape kits or failures of law enforcement to enforce or respect orders of protection and this kind of thing. Another really important thing about the ERA that a lot of people don't realize is that it actually grants Congress more power to do stuff. Section 2 of the ERA provides a grant of power to Congress to enact legislation that would serve the rights and protect the rights that are reflected in the first clause, the one that we all know about and that Kara read at the beginning of this program. And as most of you know from con law, most of what Congress does today, it does through its commerce power. But the commerce power is limited. And with the ERA, that Section 2 power would enable Congress to have an alternative source of power to enact legislation like, for example, the Violence Against Women Act and portions of that statute, the federal statute that criminalizes female genital mutilation, which one district court in Michigan has struck down as in excess of Congress's power under the Commerce Clause. So those are just a couple of the concrete ways I think it could make a really big difference. But I don't want to lose sight of the symbolic one, nor do I think that denigrates it. I think it is actually an incredibly important symbol. And as Justice Ginsburg said, she wanted her grandchildren to pick up the Constitution and see that their rights were protected. And I think that's a very, very important value that the ERA would serve.
And Kimberly, can I just add to what Linda just said? Because that argument came up a lot when we were talking about this, not only in committee in 2015 and 17, but also on the floor when we were about to vote on it. And what I asked my colleagues to do is I needed them to go back to when we first come into the chamber, before we do anything else, we say a prayer, and then we all face the flag. And we say these words. If you're talking about symbols don't mean anything, this is what we say. We pledge allegiance to the flag of the United States of America, and to which the republic for what? It stands. It's a symbol. So if symbols are not important, then we need to take that out when we first walk into the room. Symbols are not important. I need you to look at your left hand, and I need you to look at the third finger. That is not your spouse sitting on your hand, but that is a symbol to anyone who looks at it and tells them that you are married. If you look at someone who is a Christian, someone who is of the Jewish faith, Baha'i, or Muslim, we wear symbols, and the symbols point to something greater than we are. So don't stand there and tell us that symbols are not important. Symbols convey something that language cannot. And so if it's a symbol, what I said to them, humor me, okay? And let's put a symbol in the Constitution.
I love it. I love it. Judge O'Hearn, what are your thoughts on why the ERA is still needed and relevant and important today in 2021?
A lot of the arguments say that, oh, well, Congress has already passed all these laws, right? But Congress can unpass them. Congress can amend them. And we know, when you need both houses to pass something, it's going to be very tough. So you can't just rely on the fact that, oh, we now have this title and that title, and we have this law and that law that are passed. I don't consider them permanent. They could go away. They could be amended. And you're like, out of luck, wait till there's another more favorable Congress and try and get it back again. If it's in the Constitution, it's in the Constitution. It's not going to be taken out of the Constitution. I mean, not that it couldn't, but it's extremely not likely that would happen. But that's my concern. And that's why I think, it's not really a symbol, it's a real thing. But I am now convinced the symbolic part is equally as important. Thank you, Senator Spearman.
So I want to move us now to just talk about this next step, but I want to share with the audience, for those who have questions, feel free to go ahead and drop them in the chat. We are going to try to get to the questions after each section has been completed. Helene, I would like to bring you into the conversation. Many believe that the ERA would have faded into obscurity were it not for the passions of women who believe that it absolutely has to be ratified as an amendment. Can you talk a little bit about the boots on the ground activism that has gotten the ERA ratified in the last few states, and what's happening right now on the ground to get it across the finish line?
Well, that's a good question. And so first I wanted to say thank you to everyone who is here. I see a lot of new faces that I don't know. I wanted to say a special thank you to Claudia in the corner who just waved, who introduced me to everyone here at the Queen's Bench and with the support of California Women Lawyers Association. So having said my thank yous, well, I came to this work through my late mother-in-law, the Reverend Katrina Martha Van Alstyne Wells Swanson. And those names are important to my late husband and his family. They're New England Blue Bloods, generational clergy class. Her father was personal chaplain to Roosevelt during the war years and her father's church was chosen to announce to the world that America was joining the war efforts. She was traditional in concept, went off to Radcliffe to find a husband and quite didn't do so, and then ran off to Europe, and then later married my father-in-law. But it was the women of Africa that inspired her to come back to the United States to become a part of the women's rights movement. What she saw there was great abuse, and she realized that if women were being sexually abused there and had no one to speak to, what it must be like for women in the church. So she came and met with her father, and thus the movement for women to become ordained took a foothold here in the United States. She was scheduled to debate Phyllis Schlafly, but that went awry when an airport plane was grounded and was never rescheduled. So she came to me in after I married my late husband, William, saying that she felt that a number of her women from her generation, as she was getting ready to pass away, that it got away from them and it would be great if it could be revived. So I took it on and found that there was a number of people out there working on it diligently. Had never dropped the ball. People like Ellie Schmiel, and some like her, some don't. There was Zoe Nicholson. There was a slew of women out there who had never stopped pushing for the ERA, and that Ted Kennedy had kept it alive after it died in the House and the Senate. You know, when the deadline expired, and then when he was given a short term left, moved it over to Congressman Maloney, and then Maloney took it on, and then unfortunately her husband died. So it kept moving forward. And then during that time period, a woman by the name of Carolyn Cook, who had worked for Hillary Clinton's campaign and moved back to DC, went as a volunteer, found information dating back to the early 80s regarding the three-state strategy and drafted this and brought it to then Representative Tammy Baldwin. So then there was two lines of thoughts: start over, three-state. So being that there were so many people working on it, like Congressman Maloney, who'd been handed it off by Ted Kennedy, that while it was quiet, it was not really dead. But what I was informed of was how the importance of setting the moral compass and getting church support, religious institutions. So that's where I came in, was bringing in the Episcopal Church by proposing at the 2009 General Convention the renewed support of the Episcopal Church in the passage of the ERA, which then Tammy Baldwin and I worked getting all these other groups more focused on that. So where it stands now is Congressman Maloney, if the attempts for this three-state strategy fails, we do have a backup plan. But think about the current political environment and how polarized this is and the direction the Supreme Court is going in and what we're all looking at in the next few days with Roe versus Wade. The temperament is not good. The three-state strategy is more expedient. And I look at it very similar to this. Just as the controversial ordination of the Philadelphia 11 was retroactively recognized, that means, and where our governing constitution for the Episcopal Church is actually written by the four founding fathers of our U.S. Constitution. You can go to Trinity Wall Street and see the original documents there. They're very similar guidelines. It's procedural. So the three-state strategy, which is removing the deadline, which is where we're at in Congress. Senator Spearman spoke of her testimony. I gave some written testimony. It is currently passed through the House this session. It's looking at the Senate. We have 4 U.S. senators on it. We need Dick Durbin to hold hearings. I am hoping that Linda Coberly and Spearman and others like Melissa Milano, who spoke the other day at the Women's March and called women to contact their senators, that people here will reach out and across the networks reach out to their other colleagues and peers and organize calling U.S. senators. So that's where it at is removing having the Senate SJ Res 1 remove the deadline, hold hearings, markup session, and then a yay vote, and it gets adopted. And then it's folks like you who come January 2022, when technically, whether or not Congress removes the deadline or not, should become active, and lawsuits can potentially um, ensue. I know that during Hillary Clinton's bid for president in the state of Nevada, there was a lawsuit where someone sued saying she couldn't become president because it wasn't allowed in the Constitution because the ERA had not passed. So there'll be all kinds of lawsuits that you folks need to explore. I know that there'll be bizarros, they'll be totally frivolous, but there'll be folks out there. Think about the political environment. This is going to affect equal pay. I've stated on and on again. It's empowers women, reaffirms the rights of men, and provides a constitutional amendment for the Supreme Court justices to consider as we look at the more normalization of the LGBT community, and now with people of color and Black Lives Matter. It's going to affect every single aspect of our society. It's not simply like, it is more than that. It affects everything. We are 51% of the population. It's just that simple.
Just math. And with that, I want to really quickly turn it back over to Senator Spearman. She has to run, but I want to give her just a little bit more time to have some final remarks before she has to leave us. Senator.
Thank you. And I'm so sorry that I couldn't stay with you throughout the entire program. Just want to say this, that now, between now and the time that this process is finished, please, please, one and all, we must use this time to change hearts and minds. We have to, because putting it into the Constitution, making sure that everyone sees it's in the Constitution will not be enough. We will still have to fight the battle that the ERA was necessary, that the ERA does what it will do what we said it would do. If we don't do that now, if we're not working on changing hearts and minds right now, we'll find ourselves in the same position we were in 1954. The Supreme Court said separate is not equal, but every time you turn around, there's another lawsuit trying to make sure that people understand separate is not equal. And if you try to do that, it's against the law. So please, please, I implore you, please, let's start working on hearts and minds while we're waiting for this process to finish, okay? And thank you. I really appreciate you. Love you all. God bless, okay?
Thank you, Madam Senator.
Bye-bye.
Right. I want to, again, encourage folks, if you have questions, go ahead and drop them in the chat section and we will get to them right away. I want to move us on now to sort of where the ERA stands, legally. And it's, getting it passed in the current legal landscape that we're in today. Linda, can you talk a little bit about current key cases, including ones that might be currently pending right now?
Sure. And so you heard from Helene about SJ Res 1 and the really important efforts that are happening in Congress. And there is no substitute for congressional action. And I just want to start there because I think there's really no doubt that whatever we do in court will be easier and better and more effective if in the meantime Congress has removed that time limit. So the litigation is, in my view, no substitute for the legislation. But let me talk about the litigation. So there have been a number of lawsuits filed against the National Archivist relating to the Equal Rights Amendment. So why are we talking about the archivist, you might ask? Well, the archivist has a statutory role in our system to count up the ratifications. It's a ministerial role. The National Archivist is, I think of him, I feel kind of bad for him, frankly, because he is, by all accounts, a supporter of the ERA. He is a person who supervises the libraries of Congress and so forth, but he has the ministerial job of accepting the mail from the states and counting up the ratifications. And by statute, when he reaches the number of ratifications that is set forth in the Constitution, Article 5, he is supposed to publish the amendment with his certificate as the next amendment to the Constitution. So he has not done that with the ERA, even though we do now have 38 states. Nevada was the 37th. Or the 36th. I worked on the ratification process in Illinois, where I live. I'm in Chicago, And building on the work that so many people had done over many years, we were able to get the ERA ratified in Illinois in 2018, and Virginia ultimately ratified in 2020. So we now have 38 states. So all of the argument is that all of the constitutional requirements have been satisfied. The archivist, anticipating the ratification by Virginia, the archivist asked for an opinion from the Department of Justice, then supervised by Bill Barr, to determine what he should do if Virginia did ratify. And the Department of Justice gave an opinion that said not only is the ERA not currently available to be ratified, but it can't ever be revived by Congress. So really, the Department of Justice, the Office of Legal Counsel, went well beyond its bailiwick and kind of, I think, usurped the role of Congress in expressing a view on what Congress could or couldn't do in that respect. The archivist took that advice, and essentially he was asking his lawyers what to do, because the Department of Justice represents him in litigation. And he followed that advice and did not publish the amendment. A lawsuit was filed actually before the Virginia ratification. It was filed by a number of red states in Alabama to enjoin the archivist from publishing the amendment. That lawsuit ended up being voluntarily dismissed when it became clear that the plaintiff and the defendant agreed with each other. So the states didn't want certification, and neither did the federal government. So there was no case or controversy, so they dismissed the case. Ultimately, after the ratification by Virginia, there were 2 additional lawsuits filed. One was filed by a group called Equal Means Equal, which is an advocacy group that works toward the Equal Rights Amendment. That lawsuit was filed in the District of Massachusetts. It was ultimately dismissed for lack of standing on the ground that there was no injury and no redressability to satisfy Article 3 standing requirements in that case, because it was brought by advocates, essentially. There was also a lawsuit filed by the 3 last ratifying states, the attorneys general of Nevada, Illinois, and Virginia. That lawsuit was filed in the District of Columbia and seeks an injunction against the archivist, compelling him, a mandamus, to compel him to publish the amendment with his certificate. That lawsuit was briefed and ultimately also dismissed. The district court held that there too the states lacked standing. The lawsuit, in the other lawsuit, the court said, well, maybe it would be different if the states were suing, because the states are really suing to protect their own role in the ratification process. But the district judge concluded that because a publication by the archivist doesn't have any legal significance, that it wouldn't redress the harms complained about by the states. The court went on to decide that the time limit is effective in blocking the amendment, even despite its ratification by 3/4 of the states. That dismissal is now pending in front of the DC Circuit Court of Appeals, and the case is about to be briefed. There is, for those of you paying attention, and I know some of you are, there was an extension order granted so that the opening brief is now due at the beginning of January. There will be a lot of amicus briefs filed. I'm preparing an amicus brief, as I did in the district court, on behalf of at least 50 and hopefully significantly more this time, women's organizations in the women's movement, including Time's Up, the ERA Coalition, Now, Feminist Majority, and many other groups. So we'll be filing those amicus briefs at the start of the year. There will also be an amicus brief by state AGs, led by New York, which is a brief that those state AGs filed in the district court. There was also a brief by more than 100 businesses including some very large corporations that advocated for our position, and they signed on to an amicus brief as well. So I think there's going to be a good collection of amicus briefs. To me, one of the great values of that is it raises the profile of this whole thing, because we can use those amicus briefs not only in the litigation to advocate for the legal position, but also in the legislation to draw attention to what we need the Senate to do to pass the time limit removal bill.
And I want to, Helene, ask you to weigh in a little bit and share with us about what's going on, current efforts in the Congress on this front.
Well, I can tell you that this coming Thursday, a colleague by the name of Jean Sweeney has lined up a meeting with Senator Whitehouse's office, who's on the judiciary. I have a meeting scheduled with the Durban Judiciary Liaison for Friday. I am hoping that many other women's groups will also become mobilized to follow this model. I think it's quite easy for a number of attorneys here to reach out across and do so. Maybe reach out to the American Bar Association to endorse SJ Res 1, reach out to your.
Oh, you've muted yourself, Helene.
For a powerful group. I am thinking, like, for example, Linda Coberly was talking about the amicus brief. Other women's law bar associations could sign on to that, not just women's groups that are involved actively in the advocacy end. I have on my website Katrina's Dream, the Power of 10 program, and it's just simply asking people each week to follow like an Avon marketing or network marketing concept where you identify just 3 people within your group that you will call, and they will call 3 like the old-fashioned telephone tree and contact the senators. We need Senators Feinstein and Padilla, who are also in the judiciary. So here's women's lawyers that could set up their own meeting right now, organized from here amongst your 2 bar association groups, and set up a meeting with Feinstein, requesting that as a member of the judiciary that she reach out to Durban Grassley, whom I believe, and you can correct me on this phone call, Linda, when we reached out to Grassley's office and they said they would be okay with a hearing if Durban would go forward. You can correct me if I misinterpreted that. But we really need to get the hearings held. There's a attorney by the name of Julie Suk who's also written a book that I suggest everybody here read. Jessica Neuwirth read a book. Those things will give you a concept of the different areas that this is going to affect, to Jessica Neuwirth's book. And then Julie Sukes gives you a little bit of a foundation of current movement, but where it's at in the Senate is it's passed through the House. The SJ Res 17, if I'm correct, bill passed through and sits on the Senate desk, but it will just sit there until we hold the hearings. And that means we're probably going to look at a filibuster. So we need someone to be able to, a senator who's willing to, I can't remember her name, but there was a politician in Texas who actually wore diapers to her legislative body to break a similar filibuster at the state level. So we really need to encourage our Democratic senators to come forward and just co-sponsor. And then there's also the possibility, this is where this current administration plays into it, is that procedurally, President Biden has already stated he's not willing to direct the AG, but we're waiting for his fellow by the name of Charles Schroeder to be appointed counsel at the White House over legislative affairs, I think it is. And then we also
actually
have,
he's
yeah, go ahead. Go ahead.
So
please.
Schroeder has been nominated to be the director of the Office of Legal Counsel in the Justice Department. And so he would have the ability to revisit the memo that was issued under the Barr OLC that could change the advice to the archivist. So he's somebody who could make a difference with that. Now, the president has made clear, and the White House made clear that their job one after our last administration is to not muck about with the Justice Department.
Correct.
So, and I think as lawyers, we can see the value of that, wanting
Yes.
to there be an appropriate separation between the White House and the Justice Department. So for that reason, the White House is not going to strong arm anyone about this, but the White House can push forward a legislative agenda in the Senate. And the Justice Department, especially when Schroeder is confirmed, as I assume he will be, would be in a position to withdraw that OLC memo and potentially clear the way for the archivist to actually publish the amendment. And then just to add on about the legislative effort, we currently have the support of every Democrat in the Senate, plus Angus King, the independent, and both Senators Murkowski and Collins, the two Republicans who have co-sponsored the bill. But unfortunately, that adds up to 52, I think. So we are still facing an issue with the filibuster, and that I think at the moment presents the most significant challenge to us. So what we really need to do is get Republicans to support this bill. And there's a lot of grassroots efforts happening with lots of different organizations to reach out to Republican senators and to try to get them to enlist their support on the bill.
Or just get rid of the filibuster.
Right. Well,
that.
you know that. Well, you know, I've had conversations with the Episcopal Public Policy Network, and you see, there's that separation of powers thing is really important here when you look at the Supreme Court. So that's why the lawsuits really need to be bolstered by the removal of the deadline. And that's what Linda was speaking to earlier, was that it becomes a no-brainer when you remove the deadline. It's just really a great place to build from.
I want to talk a little bit. Let's see, we have, I think, just a few minutes left. Wanted to see if there were any questions. We have some comments here in the chat section. I believe Jay Sweeney says that there's a great 30-minute film on Vimeo on the ERA, which is done by activist Kamala Lopez. Watch it if you can, done in about 2015, but gives a solid background. Legalize Equality is what that is called. And then we have Denny, who said that in in North Carolina, very tightly locked up in the Rules Committee in both the House and Senate. Wanted to see if there were any questions that have come in so far outside of the comments. Alicia, anything from your end? If not, we'll move on to the next section.
None on my end. Thank you so much.
So let's talk a little bit about the states and if they have the ability to rescind their support of a constitutional amendment before it's finally ratified. Linda, can you talk a little bit about this issue?
Sure. So in the 1970s, there were 5 states that voted to ratify the ERA, sent their ratifications in to the archivist at that time. And then later, another legislature in the same state voted to rescind or limit a prior ratification. So one legal question we have is, what's up with that? And does that really mean that we're actually at 33 states instead of at 38 states? And I think the answer to that is no. And there's some good historical precedent for that idea, and that's that a ratification is something that happens at a moment in time. The state's only responsibility is to have its legislature, not its governor, but its legislature, vote on the amendment. And once a state ratifies, its job is done. It has no continuing role in continuing to support the amendment. And the best historical precedent for this is the 14th Amendment, in which two of the necessary states did vote to rescind a prior ratification, and yet those two states were counted among the states that ratified the 14th Amendment and were counted to the total to put the 14th Amendment over the finish line. And yet all three, again, all three branches of federal government at that time recognized that the 14th Amendment was validly ratified and part of our Constitution. So that's a pretty powerful precedent for the idea that once a state ratifies, it can't take its ratification back. There is now actually a sixth state that has tried to do that. North Dakota, just a year or two ago, passed a bill that would purported to limit a prior ratification. But again, that's not the role of the state. The Supreme Court has held that the Congress has broad plenary authority over the ratification process. It has power over the process from beginning to end, and that ultimately it's up to Congress to decide what actually counts as ratified. And that's one of the reasons why we think it's so important that Congress act at this point, because if Congress were to remove the time limit, I think there's a strong argument that the appropriateness of that decision, that's a political question and it's not for a court to resolve. So that's one of the reasons why legislative action is so important at this point.
So let's talk a little bit, and Helene, I want to bring you into this part of the conversation as well. If we can talk a little bit about what happens if the resolution to ratify fails to pass, or if the court cases fail.
Well, the only way it can fail at this point is if we don't have the hearings, and it's not necessarily that we don't have the hearings. We could take it straight to the floor for a vote. And there's always that long shot that the president of the Senate, Kamala Harris, could somehow interject somehow. I don't know the procedure there and how that works, but I do know she's president of the Senate, and there are some maybe potential procedures that have not been fully explored, but we don't want to go off that correct policy and procedure course. The procedures are there because they're a foundation, and once you start shaking that foundation and separation of powers, which is what we saw taking place with Trump's administration was really mucking things up, and Biden's administration is trying to firm up that foundation. And now we have a Supreme Court that is, if they are true constitutionalists, like they have testified when they're being nominated, then we should do really well. Okay. And I think we will. But when we look at what's going on with the, what's going on is, I think if it doesn't get through this time and it doesn't have a hearing, then you reintroduce it in the next legislative session. But then you have to consider, what does 2022 look like in the next coming midterm elections, right? So do you really want to wait to 2024 and then during that time period, Linda and Big Law and others?
You accidentally put yourself on mute again, Helene. Sorry.
Walmart's versus Duke's is when Scalia spoke before the Hastings Law School graduating class and made his statements regarding, well, if there had been an ERA, okay, so there's going to be creative types in January 22 from both sides who are going to use this to further their own personal political agenda or their moral compass and how they see this working out. We've got cases like Hobby Lobby. You know, we have this as some people thinking this is the ERA does or doesn't come under the Equal Rights Amendment, but pharmaceutical companies have already started acknowledging that the way they've developed prescription formulas in the past have been geared towards men. So there's going to be a lot of changes. So I see all these different potential lawsuits and that when you remove the deadline, I think the issue really then becomes in play when Congress acknowledges that removal. It goes straight into play January 2022. Salesforce already has software that they're offering companies to get in compliance. So security changed all their rules to be in compliance. The military is really not going to have a big problem. They're trying to adjust, their policies. So really, it's going to come down to equal pay, and I think we're ready to roll. I don't see any real problems if we can just move 10 Republican senators to voting yes. And I think they're out there. I think, like the Democrats who have not publicly supported it, but say they are, there are Republican senators out there that do support it. Grassley voted for it when he was in his own Iowa assembly. There's Loomis, who was previously for it, but says she's got some concerns right now. So there are Republican senators who have in the past supported it when they were younger legislators, and there's younger women senators that are Republican that could come on now. So I think it's really like Linda was saying, let's focus on some Republican senators and bring them together and depolarize this to some extent if we can.
Well, I will not admit to being the most optimistic in terms of moving the needle in that direction, I must say. And as someone who, I don't know, I kind of perceive myself to be somewhat impatient, or quite frankly, very impatient around this issue and around a lot of issues that impact women. And so, a rhetorical question based on everything that you've just shared, Helene, how much faith do we have that the Supreme Court, the current makeup of the Supreme Court, are true constitutionalists who believe in tradition and foundation and who are not really utilizing this moment, in addition to the hundreds of judges that were appointed across the country at every level. And, to your point,
Clarence Thomas Kavanaugh. Clarence Thomas Kavanaugh. Two names. Clarence Thomas Kavanaugh. Again, how did they get there? How?
Yeah. So if we, to your point, waiting to 2022 to see how that shakes out.
Yeah, so I know this is it. This is what I'm saying.
That's kind of scary, right?
October, November, December, lawsuits get filed January. Then you've got to do the demurrage, venue, jurisdiction. Okay, so that brings you to March, April. Then maybe they've got the seal that you can proceed.
Run the clock out, right?
Discovery. So how much time do we have? Literally, we have to the end of next year.
So just on that, and I want to get Judge O'Hearn in here. Why wouldn't we just at this point, just looking at the history and all of the obstacles and roadblocks and the riders and all of the technicalities that have been used and will continue to be used to stop this in its tracks? Why wouldn't we bypass a hearing? Why wouldn't we go straight to the floor? Why wouldn't we call the question right now to see where things stand? Let me get you, Judge O'Hearn, to jump in here.
Thank you. I was so hopeful in 1978. We got the extension to 82. We only needed 3 states. It's a shoo-in, right? No. 1982 comes, we're still short 3 states. And look how many years later that we get those 3 states. I'm glad that it's being revived a bit more, and I'm inspired that other people are hopeful. I'm trying not to be too pessimistic, but we'll see. I'm counting on other people to carry it on.
Thank you for that. Well, I do think that we are getting close to our end time. So I want to get ready to have all of the panelists share a few closing remarks. And I will just say again how incredibly grateful I am for having had the opportunity to be in conversation with you all tonight. And if I could just add, as the newish director for the Department on the Status of Women, one of the narrative changes that we have been championing in the 10 months that I've been there, that we will continue to champion. And it deals with one of the issues that the department deals with, and that is domestic violence. And what we are saying now is that domestic violence is not a women's issue. It is a societal issue. And it is not fair nor morally just to ask women, and only women, to deal with and to solve that issue. Everybody in this society must commit to eradicating all forms of gender-based violence. Similarly, to the comments that were made earlier about the myriad of women's organizations and groups that are being called upon to help and to support this effort, I would encourage us to also ask our men and our male allies to join us in this as well. This should not and cannot be a cross that we bear alone. They must also be standing with us shoulder to shoulder. And so whatever support I can lend towards getting the 49% of the population to stand with us in this fight, please count me in for doing that. And with that, I want to turn it over to Linda, and then Judge O'Hearn, and then Helene for final remarks, and then back over to Kara, who I believe will be closing us out. Linda.
Sure, I love your point and think it's so critical. And one of the things I see as a strength of the ERA is it actually, I mean, I think we all like to say, let's put women in the Constitution. The ERA actually wouldn't do that, right? Like the word woman is not in the ERA as currently formulated. What the ERA does is it bars sex discrimination on the basis of sex. And some of the cases that Ruth Bader Ginsburg brought to ground a sex discrimination right in the 14th Amendment were actually brought on behalf of men, because those were good cases to litigate. And I'm sure that when we do start seeing litigation to enforce the ERA, we're going to see litigation brought on behalf of men who are challenging sex discrimination. And that's okay, because that's what the ERA is designed to do. Just take sex off the table as a way to treat people differently. There's one other really important implication that the ERA would have that we haven't talked about yet, and that's with respect to LGBTQ people. We know from the recent decision in Bostock that discrimination on account of sex includes discrimination on account of sexual orientation and gender identity. And I think some of the clearest and best cases to bring when we start litigating over this are going to be cases of states that are discriminating against trans women athletes. Solely because they have trans status and they were born and assigned male at birth. I think those kinds of cases are clearly, that kind of treatment is clearly a violation of an Equal Rights Amendment, and those will be good cases to litigate. And that's one place where I think the ERA could make a massive difference in the rights of people on the ground, because the rights of trans people are so embattled right now. So I think it's important that we build these kinds of coalitions across groups of sex identities to really embrace this concept of an ERA.
We don't hear you.
Kimberly, there you go.
Judge.
No, I
Judge
can hear
O'Hearn.
you. Yes, I gave my personal remarks, so I just want to give a quote from the 1978 speech that Representative Barbara Jordan made in Congress. And she was the first Black Texan elected to Congress. And what she said in her speech was the Equal Rights Amendment is about human values. It defines the standard by which future Congresses, legislators, presidents, governors, and courts will define human relationships. Governors It amends the equal protection values of the 14th Amendment beyond race and national origin to include gender. It is about equality and freedom and the pursuit of happiness. So that's all I wanted to add.
I guess what I would like to say is this. I truly believe the ERA is going to happen. It's going to pass, be adopted into the Constitution, and that the women here today and the men you'll reach out to, as Kimberly's mentioned, that need to be on board too, that this is going to be a new body of law. I worked for an attorney by the Melvin Belli. He was a jerk, trust me, but he was brilliant mind. Okay. And when I see how this is going to unfold as like demonstrative evidence, he was a father of demonstrative evidence, that there's going to be changes that are significant that are going to affect everyone's life in a really wonderful way. And that it's the folks here that are going to be on that cutting edge who will sue on behalf of the male child who gets bit on the face by a dog, who is not valued as much as the young girl who is already being sexualized for a bite on her face, to the couple that have been together for a number of years of the same sex and have children, to the transvestite who wants to be able to just walk down the street without being fear of being murdered. I think it's going to be really wonderful things. Criminal defense, hate crimes will look differently. Domestic laws, family law, it's all going to change. And you folks are going to be the attorneys in this next wave that define that. So I'm really honored to be able to just light maybe a spark in all you brilliant minds, legal beagles, eagle eyes, who know how to cartwheel and look to Blackstone and to the future. Thank you.
Our esteemed panelists, Linda, Judge O'Hearn, and Helene. Cara, take it away.
Well, thank you so much, Kimberly and panelists, for doing a fantastic job. So I am putting in the chat the SurveyMonkey survey link for those of you who are eligible to receive MCLE credit. Again, please copy the link and fill in your information, and in approximately a week, you should receive MCLE certificate. If you have any questions, please contact the Queen's Bench administrator at the same email as how you received the Zoom link. Otherwise, if you want to revisit the panel discussion at a later date, it will be uploaded to the Queen's Bench YouTube channel in the near future. Otherwise, anyone, Alicia or Beverly, have any announcements?
No, just to say thank you again for everyone who's participated and made this event happen, and for everyone who joined us today. Thanks so much.
Yes, thank you.
Thank you to our coordinators.
You all, it's been great. Thank you so much. Thanks to all of you who could join us, and have a great evening.
All right.
Thank you, everybody.
Thank you.